So, welcome to the second conference of the PRIN-PROJECT on digital vulnerability in interaction with AI. The whole DIVE team and I thank you all for your enthusiastic reply to our invitation and calls for papers and the commitment to contribute to the discussion on the human vulnerability in interaction with AI. Let me shortly introduce the conference, starting from a basic statement. Humans are relational beings, and these relational features play a role for the single and her identity development, and for the community and the creation of the societal structures and common narratives. As Norbert Roland says, the human species is characterized by cultural variability. Humankind celebrates difference in order to forge its own identity. We exist only in relation to others, finding our place in a continuum stretching from the familiar to the unfamiliar. With regard to the concept of vulnerability, the starting point is that it is related with the relational nature of humans. Human vulnerability implies relationships. The relationship could be with other humans or other beings. In this sense, ontologically, any being is vulnerable. Law itself is based on the principle of human vulnerability. Societies need rules to protect their members, to prevent harm, to preserve order or restore it once disrupted. Subjects protected by the law are traditionally legal subjects. They are natural or legal persons, even if the legal person is a fiction that hide one or more natural persons. Thus, private law is focused on the relationships between legal subjects who are de facto humans. However, private law also regulates the relationship between legal subject and things, property law, tort law, and so on. The very evolution of the human race is related to the invention of things. Humans invent things and tools to make life easier, to increase their power. Some of these inventions were revolutionary, like the wheel, the plow, the printing press, or the steam engine. In this regard, AI is an invention, a revolutionary one which is shaping our world. As the other inventions I mentioned, AI is a product of human creativity and a tool. As any new technology, it creates opportunity and risks. Now, the regulations of AI systems already in force or about to become in Europe, in US, in China, treat AI merely as a product or a tool. That's the right way to deal with most of the technologies already in use. But the question is AI a thing, a tool, or a product as any other invented by humans throughout history? Are the legal instruments mankind created over the centuries adequate to deal with such a revolution? The first conference of the PRIN-PROJECT held in Ferrara last year was dedicated to AI as product and tool, considering the humans as consumers of digital products and users of digital tools. What inspired this second conference was a different perspective. The perspective provided by observation of the special and deep interaction humans are creating with AI. Not a complex interaction, but rather an easy, maybe even too easy and ongoing interaction. Although the profiling algorithm belongs to a relatively simple digital technology with the aim to promote business, to simplify communication and research, to improve the online experience and so on, it has been proven to have distorting effects. Information bubbles and political polarization are examples of this. Although social media was not intended to spread misinformation and was not designed as a weapon for disinformation. In this regard, deep mediatization is a highly contradictory meta process of change, socially bound and solidified within numerous other sub-processes. Societal and individual identity-building processes are transformed when entangled with AI. These processes remain grounded in human practices, that's right. But are societies and individuals aware of this and prepare to these changes? There is a need for a renewed humanism, one that recalls people that their vulnerability rather than their power. Let me return briefly to the vulnerability as a relational condition. This conference focuses on the interaction between humans and AI systems, those that already exist and those of the next generation, self-trained learning and generative technologies, artificial intelligence that mimic humans and give them the illusion of a relationship. The deeper the entanglement with AI, the deeper the relationship and the risks of distortions and unpredictable or intentional manipulations. AI imitates humans, their behaviors, their features. AI is like a mirror, and humans, in particular in Western individualistic culture, are inclined to narcissism. The threats lies in that mirror-like operability of AI systems and their interconnectivity. What humans perceive as a relationship or a social environment is, for a digital machine, a set of connected data. The central issue here is the construction of a meaning and sense-making in times of human-machine interaction. The anthropomorphization of AI, see, my PhD students, they know that I have a problem with the words. So I put this word there just to let them laugh. Okay, got it. The anthropomorphization of AI seems to be intrinsic in the field of AI developers and researchers, where it is very common to use terms typically used to describe human skills and capacities, and to focus on alleged similarities between humans and machines, especially in brain-inspired AI. The problem is that omen nomen. The tendency to project typical human traits onto AI has significant epistemological implications. In the general public, it promotes misleading interpretations of what AI is and what its capabilities are, with consequences for the social dynamics. At the individual level, the tendency to anthropomorphize AI shapes the way people form their own identities, the way they behave, express themselves, and make decisions with implications for their self-concept. Both these epistemological implications have juridical and ethical consequences. One among many is that perceiving AI systems as human-like might entail considering them as moral agents and their actions as the result of autonomous decision-making process. Thus, such anthropomorphism might create confusion by blurring moral and ontological boundaries. In short, human inventions promote the progress as they shape the world. The peculiarity of the digital revolution is that it's driven by a machine and artificial things which behave like a being. Therefore, when analyzing the digital revolution under the legal lenses, jurists need to widen their perspective beyond traditional conceptualization. The paradigm shift requires a collective intellectual effort. The digital revolution is multi-layered and demands a multidisciplinary dialogue with philosophers on individual identity, subjectivity, and agency, with sociologists on societal dynamics of inclusion and exclusion, with digital health experts on the phenomenon of human-machine hybridization in the broadest sense. My special thanks go to all of you, dear colleagues and friends, for sharing this multidisciplinary approach with us, and to the many PhD students that are here, some just to attend, others also to present their researches on the matter. They represent the new generation and have a right to be heard and to contribute to the debate on their future. I wish you all a pleasant and enriching exchange of knowledge and opinions. Thank you.
Good afternoon, everyone. Like my dear colleague and friend, Amalia, I'm happy to welcome you to our conference in this beautiful complex, and I'd like to thank you all for being here. Our today's journey is not just about exploring the interaction of human with AI. It's about questioning whether this interaction is actually guided by a human-centered approach to AI, taking into account, as Amalia said, the fluid, multi-layered, possibly vulnerable nature of the human condition. So before we embark on this conversation, I thought I wanted to emphasize that the legal landscape has much changed since we began our research project on digital vulnerability and European private law 4 years ago. At the end of the 2020, we claimed, among other things, that even though the notion of vulnerability had gradually emerged in the legal discourse, the full potential of the notion of digital vulnerability was still to be unlocked, at least at the legislative level. It was more like a scholarly notion. The opening meeting of the project, which took place last year in Ferrara, was the first attempt in this direction. It was devoted to the various forms of exposure to harm arising out of experiences of digital technologies. With the introduction of the long-awaited European Union Artificial Intelligence Act, Europe now has established the most comprehensive regulation of AI globally. The approach taken by the Act is labeled as risk-based, in the sense that the riskier the AI system, the more rigorous the regulations. The Act considers the potential impact of AI systems throughout their entire life cycle, from design to deployment and beyond, and it seems to me, I might be optimistic, like Marta was telling me, that in the Act, vulnerability alongside fundamental rights are both key factors in fostering the development of responsible, ethical, and trustworthy AI. I'll provide only a few examples of this evolving landscape, as I anticipate that in the hours ahead, we will delve deeply into discussions regarding the transformative potential of integrating AI, human vulnerability, and fundamental rights within a unified framework. As for vulnerability, one specific significant issue is the need to make the notion of high-risk systems adaptable enough so that the legislation can be applied in a manner that is to say future-proof. The AI Act does not provide, as you know, a definition nor a definitive list of high-risk AI systems. Instead, it sets forth criteria for evaluating the risk level of AI applications on a case-by-case basis. The Act grants the Commission the authority to revise these high-risk system use cases and specifically includes the consideration of whether the system engenders an imbalance of power or whether it places people in a vulnerable position in relation to the deployer of an AI system. In particular, I quote from the Article 7, letter H, due to the status, authority, knowledge, economic or social circumstances, or age. In essence, the AI Act offers one of the broadest normative definitions of vulnerability within the digital realm. It is true that certain provisions, such as Article 5, for example, hint at vulnerability of specific individuals or groups, such as children, persons with disabilities, elderly, marginalized communities. But it's also true, however, that the Act does not confine the concept of digital vulnerability to these categories. It acknowledges vulnerability to potential risks posed by AI systems as a contextual, relational state determined by specific circumstances. And this aspect of the Act, in my view, is a big win for the human factor. Consider that AI reshapes so many areas of human life, from healthcare, education, governance, administration of justice, etc. Another big win from this perspective is, in my view, the fundamental rights impact assessment for both public and private actors deploying AI across Europe. Well, the exact scope of the fundamental rights impact assessment is not yet fully clear. And there are open-ended questions as to how to combine the fundamental rights impact assessment with similar requirements, such as the data protection impact assessment that will still be required for many high-risk AI systems. However, it is clear that requiring a solid and sound fundamental rights impact assessment is a key part of grounding AI regulation in a human-centered and trustworthy legal framework. And this fundamental rights impact assessment is actually a big win not only for the human factor, but also for the scholarly community, as many of recent major developments in the field have been pioneered and even pushed on by legal scholars in academia. AI and emerging technologies have widely transformed academia, but in this instance, we can say that the opposite is also true. Academia has indeed actively participated in shaping the norms of the digital society, and I'm so pleased that some of the scholars who prompted a need for a new shift are today in this room or have accepted to contribute to the volume collecting the proceedings of the conference. And speaking of proceedings, I'm pleased to announce that Nomos will soon publish an open access volume collecting the proceedings of the Ferrara conference, titled The New Shapes of Digital Vulnerability in European Private Law. The volume is edited by my dear colleague and friend Camilla Crea alongside Alberto De Franceschi, whom I don't see yet. It's coming. Regarding this conference, both Amalia and I are thrilled to share that the proceedings will be published by Springer by the end of the year, with hopes for timely completion. We kindly request all of you to submit your contributions by September 1st. Does it sound good? At latest. And of course, we'll provide the guidelines for manuscript submission in the upcoming days. So once again, I express my gratitude to all of you for being present. And now I would like to invite the chair of our first panel and all the distinguished speakers to join us on the stage. Thank you.